California Lawyers for the Arts is very proud to present Modeling Law, a Know Your Rights presentation for the established and emerging model. Our presenters tonight are Ms. Carmen Caserta and Ms. Julie Lim from the Catwalk Counsel. It is a law firm providing service to professionals in the fashion and arts industries. Let's have a big round of applause. Let's begin.
Thank you. Well, hello, everyone. Thank you for being here. My name is Carmen, and I am a practicing attorney here in the Bay Area. My practice is called the Catwalk Counsel. I specialize in fashion and the arts. My main areas of concentration right now are trademark counseling, copyright protection, and a lot of contracts. And basic general counsel. So that's kind of means whatever my clients need. And this is my colleague, Julie.
Hi, everyone. My name is Julie Lim. I work with Carmen at the Catwalk Counsel as an of counsel. And I'm super excited to be here today. Thank you, everyone, for coming out on a Tuesday night. I'm really excited about our discussion on modeling law, because I actually used to be a model before I started my legal career. And a lot of the issues that we're going to be discussing today, I can definitely relate to. So I hope that you guys can find this discussion informative, helpful, and practical for yourself or someone who you know wants to be in the modeling industry or who already is.
Fabulous introduction, Julie. We're super excited. We've put a lot into this presentation. You know, we're focusing on areas of the law that are super relevant right now. The three main areas we're going to cover are independent contractor versus employee. So the differences there, the implications of each designation, rights of publicity, and sexual harassment. So as most of you probably know, there's been a lot in the media lately about sexual harassment, and there have been a few exposés about sexual harassment, specifically within the fashion industry. So it's an age-old issue, of course, but there's a lot of conversation about it right now. So we really felt compelled to touch on some of these issues and, help to put the law and, models' rights into hopefully, easy to digest language for everyone. So shall we just dive in?
Yeah,
Shall we start?
Get started.
Okay, let's dive into some employee versus independent contractor discussion. So does anyone want to kind of take a stab at describing the difference? Anyone have any ideas? Absolutely. So absolutely. And the key, I think, that you touched on there was the aspect of control. So does anyone else want to throw in any other ideas? Okay, so what was your name again? I'm so sorry.
Lauren.
Lauren. Okay, so yeah, Lauren hit it on the head when she spoke about control. So there's some real sort of like legal jargon heavy definitions that I'm just going to go over really quickly, but we'll talk more about it in kind of more layman's terms. So an employee is defined in the California Labor Code as any person rendering service for another other than as an independent contractor is presumed to be an employee. So that's California Labor Code section 3357, if anyone wants to look that up. An independent contractor is defined as any person who renders service for a specified compensation and for a specified result under the control of his principal as to the result of his work only, and not as to the means by which the result is accomplished. So absolutely, it's has a lot to do with how much control the hiring party has over the worker. So which do you think is a more fitting designation for a model? Okay, great, great, great points, because you spoke a little bit about what we call exclusivity, so that she, so that she might not be allowed to go and work for other brands or other agencies. So she may have more of an exclusive relationship with Victoria's Secret. So does anyone want to guess whether models have traditionally been treated as employees or independent contractors in California?
I'd imagine independent contractor.
Okay. Anyone else disagree? Okay, so let's consider a few things about the job of modeling. So models, typically, this is just generally speaking, okay, models have little to no control over the location of their shoots, the hours of their job. So whether it's a casting or a photo shoot, they don't get to set those hours. They just have to show up when they're told. Little to no control over their wardrobe, hair, and makeup. So, you know, most of the time the brand or the fashion house has the wardrobe that they're going to be shooting, and has a very specific look in terms of hair and makeup that the model is required to present. Models have little to no control over their clients, or they wouldn't even be their clients. So the clients are the agency's clients, right? So models have little to no control over the jobs that they're sent to, or the castings that they're sent to. How to perform the work. So when a model shows up to a casting, the model is told how to pose, how to move, how to act, what kinds of emotions to emote. You know, same as on photo shoots, you know, on set. There's also the issue of exclusivity that you touched on. So not all models have exclusivity relationships with their agencies, but many do. Many do. So there are some, you know, many agency contracts that will require models to be exclusive to that agency, so that the model is not allowed to take other jobs. Eating habits and weight are also often controlled by the agency. So considering these things, let's just backtrack real quick. You said it, Samantha, right? So independent contractor. Models have traditionally been treated as independent contractors. And you said that as well, right? Independent contractors. This has been the norm in the industry. But considering everything that we just heard, right? Little to no control over all of these aspects of the job. Why do you think modeling agencies have treated models as independent contractors? Can anyone think, just maybe spitball some guesses as to why that would be the industry standard? Please.
They're not as protected, so maybe they don't need to qualify under certain criteria as an employee versus an independent contractor, so they can do more and not have to actually protect the model.
Okay, so you mean the agency?
Yeah.
So the agency, so the agency doesn't have as much liability,
Right.
to the model. That's pretty much it. That's pretty much it in a nutshell. Yeah. Did anyone else want to add anything to that? So yeah, I mean that's it. So agencies don't have to pay. So when agencies classify models as independent contractors, they don't have to pay minimum wage. They don't have to pay overtime. They don't have to provide any benefits. They don't have to pay workers' compensation. They don't have to pay Social Security taxes. They're not limited by allowable percentages in the labor code. They can take higher percentages of the model's income from a job. If an agency's client, that would be the fashion house, the brand, if the client refuses to pay the agency certain fees, like the rights to use the model's image, the agency can actually charge the model for those fees. So the agency can take that fee out of the model's pay. Agencies, when they treat models as independent contractors, are not beholden to anti-discrimination and wrongful termination laws. They don't have to pay unemployment. I think I already said that. And they are not responsible for workplace safety. So you're absolutely right. It's all about liability. So we're going to talk about two cases, two sort of landmark cases within the fashion modeling industry. This was a California case, landmark case, back in 1980. This is actually not the model. We couldn't find a picture of the model, but he was a guy and he sued, but it's not a bad picture, you know. If we couldn't find a picture of the guy, well, hey, this one will do. So the model, Zaremba, he sued a photographer to recover for failure to timely pay wages. So basically, the photographer didn't pay the model at the end of the working day, at the end of the photo shoot. The model alleged that he was an employee and not an independent contractor, and therefore he was protected under the labor code, this labor code, section 203, which entitles him to full payment on the last day. So in California, this is a little bit, it's not totally an aside, but it's just a tidbit to know. In California, employees are entitled to full payment on the last day of work. Okay, so this model was arguing, hey, wait, I'm an employee. He didn't pay me. I'm an employee. I had the right to get paid on the last day of the photo shoot. So he sued, and the court agreed with him. The court agreed with him and said that the model was indeed an employee because the photographer controlled the model's movement, dress, hours, and place of work. So this is still good law in California, as far as we know. So this is still good law. So you know, even dating back to 1980, the courts in California are kind of saying, you know, I'm not so sure. We're not so sure if independent contractor is the appropriate designation for models, you know, at least for the purposes of things like wage protections. So our next landmark case actually comes out of New York, and this is a very recent case. I see you nodding your head. Are you familiar with this case?
I read a little bit about it.
Did you?
But not too much.
What do you know about it? Right. So, okay. So this is Nikisha McCary versus Direct Model Management. So Direct Model Management is a little bit of a confusing name because they are a modeling agency. As far as we understand it, they are a modeling agency, but they also provide management services. And there is a difference. There is a difference for legal purposes. And we'll come back to that. We should come back to that. If I forget, someone reminds me because there's big difference there. This model, this is actually her. Beautiful. This is her. She sued her agency for over $30,000 in back wages, alleging that the agency miscategorized her as an independent contractor instead of an employee, and that this resulted in illegal profits to the agency. And again, the court agreed with the model and said that she was indeed an employee because the agency required exclusivity. She was not allowed to work for other agencies or take jobs through other agencies or independently, and told her how to look for clients, where to go for photo shoots, all of those things we talked about. So the court entered a judgment against the defendant agency for back wages plus interest plus attorney's fees. So we are seeing that even though traditionally models have been treated as independent contractors on paper and in their contracts, the courts are not really always convinced that that's the appropriate treatment, that that's the appropriate perspective to take for models. So now we come to the Dynamex decision. This is landmark case here in California that just came out this year. Does anyone know about the Dynamex case? Okay, so this is a big deal, and it's a fascinating case, and it has, you know, huge implications for the modeling industry, obviously. The background is actually not really fascinating. It's kind of super boring, and it's about this carrier service, Dynamex. They deliver stuff. Okay, so not super glamorous, but nevertheless, the rule that came out of this case is very important. So we have a rule and we have a test, okay? So the rule that comes out of this case is all workers are presumed to be employees for purposes of California wage orders. Okay, wage orders cover things like wages, hours, working conditions. Okay, so this is a really big deal. This means that everyone, whether or not your contract says employee, independent contractor, whatever, every worker is presumed, which means by default is automatically an employee for the purposes of California wage orders, okay? However, the employer can rebut this presumption, can argue, no, this worker is actually an independent contractor. And the employer can do that by proving what the court has called the ABC test. So the employer has to prove 3 main prongs. Okay, the first prong, the employer must prove the worker is free from the control and direction. So again, we're coming back to the issue of control, right? So the employer has to prove that the worker is free from the control and direction of the employer in connection with the performance of the work. Okay? The employer must also prove. So this is a three-part test. So it's not that the employer has to prove one or the other. Employer has to prove all 3. Okay? So B of the ABC test. Employer must prove the worker performs the work that is outside the usual course of the employer's business. Okay, so for example, okay, let's talk about models, right? So an agency, as the employer, right, would have to somehow prove that the model is performing a task or a service that is outside the regular scope of a modeling agency. Can this be done? Not really, right? I mean, if the model is showing up for a casting, going to a photo shoot, walking the runway, all under, you know, his or her contract with the agency, that's within the scope of what a modeling agency does, right? An example of how an employer could prove this is let's take a modeling agency and just stick with that example, right? So if a modeling agency hired a painting contractor to come in and paint their offices, right? That's outside of the scope. That's outside of the normal course of a modeling agency's business and the business that they conduct. Does that make sense? Okay, everyone's with me? I feel like I've been talking a lot here. Okay. All right, so finally, prong C of the ABC test, the employer also has to prove that the worker customarily engages in an independently established trade, occupation, or business of the same nature as the work performed for the employer. So, you know, an employer can show that the worker has taken steps to create their own independent business and that they perform these same services for other hiring parties. Okay. What do you guys think this means in practical terms for models, considering these 3 prongs? Do you think models, in terms of their relationship with modeling agencies or model management companies, do you think they look more like independent contractors or employees according to the ABC test?
It seems like employee.
Why do you think?
I imagine that the modeling agency or management would have some kind of exclusivity contract where they wouldn't allow the models to work for other agencies. So that seems like it would fit with prong C. So the model wouldn't be allowed to do any independent business. And for B, the models are doing what goes into the business of being a modeling agency. And I've forgotten what A was.
So A was about the control, right?
Mm-hmm.
Control and direction of. So the employer has to prove that the worker is not sort of in the direct control of the employer.
So I imagine that the modeling agency is telling the model where to go to be shot and telling them, you know, I got this lined up for you and you need to be at this place at this time.
Exactly. Exactly. Anyone else disagree? Agree? What do you think? We're all on the same page, huh? Yeah. So, you know, it's going to be really interesting to see, right, how modeling agencies respond to the Dynamex decision and how they start, and if they start, changing their contracts. We shall see. So what can models do to protect themselves always, 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 number one suggestion, consult an attorney. So none of this is a substitute for, really having your own counsel. But we're doing a presentation, so read the terms of the agreement very carefully. Always read the terms of the agreement. Always, always, always. Something to look out for very specifically, does it say employee or independent contractor? If the contract classifies you as a model, as an independent contractor, there should not also be what? You said it.
An exclusivity.
An exclusivity clause. Exactly. They can't have it both ways, right? So if the contract classifies you as an independent contractor, they can't also have exclusive rights to you. Okay, so definitely watch out for that. And if that's in there, if both of those are in there, then that's a red flag. That the agency knows the law and doesn't care about it, or doesn't know the law, which is equally concerning, right? Other terms to watch out for that will strengthen a modeling agency's argument that a model is an independent contractor, terms that minimize the agency's control over the photographic and creative process. Okay, terms that call for the model to be in control of hair, makeup, clothing. If these are made, so sometimes a contract will make these services available to the model as sort of optional, right? And if the model, and that's a way to sort of limit liability. But if the model just says, oh, well, then I can just opt to get my hair and makeup done at the casting or at the shoot or whatever, then the agency can say, well, it wasn't mandatory. She chose that service, he or she. Okay. Also watch out for terms that describe the model as having an independent business. Okay. Also know that regardless of what the contract says, and we've seen this, right, in these two cases, regardless of what the contract says, even if it says at the top, huge, independent contractor agreement, the court will always look at the totality of the circumstances. That means the whole picture. That's just fancy legal talk. The whole picture, and apply that ABC test we talked about from the Dynamex decision. Okay. To determine what's actually going on here in fact, not just on paper. Okay. Also importantly, we talked about this too, but very important to know, you have the right to payment in full on the last day. So if you show up as a model, if you show up to a photo shoot, and it's a 1-day shoot or whatever, it's a 5-day shoot, on the last day, you have the right to full payment right then and there before you leave. So you can be confident in demanding that payment because you are considered by default an employee for those purposes. Okay. If they fail to pay, they can be subject to penalties, and you have your code sections up there that you can refer to for that. Before we move on to right of publicity, which is super fun too, any quick questions about what we just covered, independent contractor versus employee? Yeah? We're good to go on that? Okay, so now Julie's going to take over and talk about right of publicity.
Thank you. All right, so the next section is the right of publicity. Does anyone know what the right of publicity is? Yes, perfect. Yeah, and why do you think that might be important for models? Yeah, wow, you got it right on the nail. So here's the rule. The rule for right of publicity is that no one is allowed to use another person's name, voice, signature, photograph, or likeness in advertising or soliciting without prior consent. And what that essentially means is that each and every one of us, you don't even need to be a model or celebrity, we have the exclusive personal right to control the commercial exploitation of our own name, our own likeness, our own persona. So you can imagine why this might be really important for models, especially because this is their bread and butter. The moment that they attach their face with a product, with a brand or company, in a photo for advertisement, they better be paid for that, right? Because that's the way that they earn their living. And because that's the way that they earn their living, they should be able to control what photos get to be released, what photos they want to be in, what brands they want to associate themselves with. So there are actually several ways that the right of publicity can be violated. The most obvious one is if there's no consent given. So the model didn't agree that those photos of her can be released for commercial purposes. But what most likely happens is that the model did give consent. It's just that the company who's using those photos goes outside the scope of that consent. So that could be the purpose, that could be the territorial usage, the time period, or media usage. So for example, I have Kaia Gerber. I don't know if anyone knows who she is. Well, she's like a very famous model right now in the fashion industry.
Cindy Crawford's daughter.
Yeah, she's Cindy Crawford's daughter. So she's really hot right now. And she's wearing YSL's clothes for Saint Laurent's advertising campaign. I believe this is for the fall 2018 collection. And she's on their social media. She's on a billboard. And what most likely happened here is that Kaia gave consent. She licensed out her publicity right so that YSL can use her persona in association with YSL's clothes for their advertising campaign, right? Now, a way that YSL can exceed that scope of consent is if, YSL decided that they're going to use these photos to promote drugs, when Kaia only agreed that these can be used for clothing and accessories. Another way is if YSL decided that they want these photos to be used in China, but Kaia only agreed to the US. Or if YSL used these photos 80 years down the line, but Kaia only agreed to 20. And actually, time period can be very, very important when it comes to nude photo shoots or risque photo shoots, because when you're a younger model and you're trying to start out, you're dabbling with modeling, maybe you want to do it, maybe you don't. Let's say that later you decide, I don't want to do modeling anymore and I want to pursue a legal career. These photos, if they're around in perpetuity, that could be damaging to her professional reputation, right? When she's trying to build it. So that's something to consider. Another one is media usage. YSL here is using it for Instagram and billboards, but if they decided that they want to put it for an advertisement in print, and Kaia only agreed social media and billboards, then that would be exceeding that scope of consent. But a more complicated way that a right of publicity can be violated is if a company receives a license from the photographer, but then and that photo has the model in it, and they fail to secure the rights from the model herself. So there's two licenses that come into play, actually. You need the license from the photographer and the model to use her publicity, right? So for an example would be if, let's say, Kaia, she had a personal photo shoot with with a photographer, and YSL is not even in the picture, and she happened to wear YSL clothes. And the photographer was actually able to secure her publicity right license so that he could use it on his social media or his homepage for his portfolio, right? And then let's say that YSL came across these photos and was like, wow, like these photos are amazing. I love the way it's shot. I love the way that the clothes drape on the model, and they want to use them. Well, YSL will have to get a license from the photographer and from Kaia, because they're going to be using her persona in association with their products for their advertising campaign. Of course, the right of publicity is not absolute. There's always exceptions, limitations, and there are three here. There's the non-commercial use, newsworthiness, and artistic expression. Now, to be covered under the right of publicity, the usage of someone's likeness must be used for commercial purposes. So if it's not commercial, then that's fair use, right? So it's okay to take pictures of people in public and then even to post these photos on a public website, because that's not being used for commercial use. So for example, today I have photos of Kaia Gerber right now, right? Am I violating her publicity rights? Most likely not, because I'm not getting profit from using her persona. There's no commercial purpose. This is solely to teach what publicity right is. So the problem only arises when there's an exchange of money related to those images. Whenever you look at a photo, you have to think about, is there a commercial purpose? So for an example, if we're talking about a street style blogger, let's say she takes a photo of, you know, some people on the street of their outfits, and she posts it on her blog saying, you know, this is someone wearing this specific brand, and she lists all the brand names, right? That's fine, because that's more likely, you know, reporting who's wearing what on the street. The problem becomes when she starts, you know, inserting links like hyperlinks and hosting advertisers, and maybe that money monetizes her blog. Then that would slowly turn into a commercial purpose. The next limitation to right of publicity is newsworthiness. This is when the person is using the image and doing so in order to report or comment on matters of public interest. Can anyone think of examples that might be considered newsworthy with regarding to models?
The bar is very low.
No?
It's a very low standard.
Okay, well, I can give you an example. I actually have it on the slide right now. So going back to Kaia, she's on the street. She's wearing a really cute dress with combat boots and a leather jacket, right? And she's walking to her car. So how can this be considered newsworthy? Well, a street style photographer actually took these photos, and this was happening during Paris Fashion Week. So the street style photographer was reporting on who was wearing what during that week, and that might be considered newsworthy to people who are actually interested, right? And as she was saying, you know, newsworthiness is a very low threshold. So as long as people find it interesting for any reason, that could be considered newsworthy.
Yeah, like where they're getting their coffee, or where they're having lunch, or whatever.
Mm-hmm.
So these kinds of photos, you know, they're not in violation of the right of publicity because they're newsworthy. Because, I mean, you know, we are a celebrity hungry culture, right? So all of this stuff is newsworthy.
Mm-hmm.
Yes. That's an interesting idea. I mean, I would venture to say yeah. I would venture to say yes. I mean, she's the daughter of Cindy Crawford. We know plenty of you know, children of famous people who in their own right don't necessarily have, you know, fame per se, right, in and of themselves if it weren't for their famous parents. But we see pictures of them everywhere. So, I mean, I would say probably so. That's an awesome question, and I think the answer is probably a bit complex because you're right, it does implicate other privacy laws. So there are laws, you know, that are considered privacy laws. The right of publicity is just one of them. And I'm not sure how to answer it super concisely in this moment and stay on track, but you know, I think probably, you know, you could make an argument of, you know, invasion of seclusion, you know, something like that. So I think I might just say yes, probably so, but it depends, and that's just like the perfect lawyerly answer. You know what I mean? But definitely, because I mean that's, you know, I don't know, newsworthy. I don't know. She's going out getting her newspaper, whatever, nip slip. That's okay. That's a little bit. It's a little bit much. That's a little different, right? That's something different from newsworthiness. So awesome question. And I'm sorry we can't have a whole discussion about it, but maybe after. Okay.
Okay, that brings us to the next limit on right of publicity, which is artistic expression, which is covered under the First Amendment. So sometimes taking photos or having a painting with someone else's likeness does not violate the subject's right of publicity if it's considered an artistic expression. So there's that balance, right? You have the artistic expression under the First Amendment, and then you have your right to privacy. We know, at least in New York, there was a New York case where a photographer was taking photos of people walking down in Times Square, and he took these photos and he displayed them, and he even sold them. So it's like there's commercial use, right? And the one of the subjects actually sued him for violating her right of publicity, and the court actually dismissed the claim, finding that sometimes the artistic expression is more important than the right to privacy in that specific instance. So you have to be very careful though, because that doesn't mean that all photographs are considered artistic. What is considered artistic? I can't even explain. It's that gray area of the law. So if you come across that question, always consult an attorney to make that analysis for you. But if you can't, I think it's best to consider two things. Are these photographs transformative enough to make this photograph maybe considered art? And two, how many copies are being produced? Because if you're having a mass production of these photos, then it's most likely leaning towards commercial use. But if you have one single copy, like a limited edition for a collector's copy, then that's probably going to be covered under artistic expression. So how can models protect themselves with regard to right of publicity? Like I said before, it's always a good idea to consult an attorney whenever you're dealing with a model release form, which captures, it lists all the things that the model is giving up with regard to a publicity right. But if that's not financially feasible, then you need to carefully review the model release form. I know a lot of models who tend to just sign it because they want the exposure, and they don't want to test the agency out because they just want to get in. But I think it's very important for models to have that self-respect for themselves and to consider, what things are okay for them, what things are not, like their hard no's. But these are the clauses from A through H of what they should consider. The time duration. How long can the client use the photo? Is it 5 months, 1 year, or indefinitely? How about the geographic territory? How expansive do you want the photos to be used? The types of media. Which types of media do you want your photos to be used in? Are you okay with only print, or maybe you only want to be on Facebook but not on Instagram? Purposes of use. What are the photos going to be used for? Now this could be important for some models if they have certain political views that they really live by, and they don't want their persona to be associated with something for a specific political cause that goes against their political views, right? So that's something to consider. Brands and companies. Which brands or companies can use your photos? Another example is if maybe you're a sustainable fashion advocate and you only want to work with specific brands that are congruent with those values. So maybe you don't want to work with fast fashion brands. Another one is editing and graphic manipulations. So to what extent are you okay with photoshopping? Because some models, maybe they want to preserve their natural beauty, their authenticity to their viewers, for the public, because that's part of their brand. So maybe they only want only lighting enhancements or only a few retouches here and there. But they would need to be careful with something if there's more like a complete face body alteration where you lose 20 pounds within a few seconds, right? Approval rights. Do you have the right to approve the photos before they are used for a campaign? And lastly, what exactly is allowed and what exactly is not allowed? So this is going back to what I was discussing before. When a model starts out, they're willing to agree to everything and just sign the paper. But if there's something that you're really uncomfortable with, convey that in the release form. And lastly, beware of boilerplate language with no conditions, wherein you give the rights to your image and likeness for use anywhere, with any and all modifications permitted for eternity. So this is a very broad clause, right? And so you always want to avoid that kind of contract, but if you can, at least try to limit that broad scope. Any questions? Yes.
If you have, I'm just trying to play this out in my mind. So a photographer has given you a model release, and then you have written in some additional provisions, changed some terms. That's actually a counter offer. And then you both sign it.
Yes.
I mean, that's there shouldn't be
I think that's fine.
there shouldn't be a problem with that, really. I mean, if it's a document that has both signatures on it.
Even if it's crossed out and stuff, I don't need to go in and have.
I mean,
those
look, it's bad
initials.
form.
Yeah.
I, as an attorney, would never have would never do something like that. I would never advise a client to. I would just retype it.
Right.
So I mean, if I'm giving you advice, which of course I'm not, but I would say, yeah, I mean, make it as professional as possible. And I mean, if it's something that you are aware that, okay, this, you can anticipate some arguments like that, then just retype the thing, but or make a copy, if you can make
I always
copies.
make copies.
Yeah.
The problem is
Yeah, I mean, it sounds fine to me. Julie, what do you think?
I think I've seen that actually before.
Yeah, I mean, you're
And it
there
seems
on the
like it's
spot.
fine, yeah.
You don't have time to redraft the thing. Date
Yeah.
date the changes, okay, and put your date next to each change, and then have the photographer date his signature. I mean, that's pretty good. Pretty good. That was my Larry David impression. Anyone? No? Was that pretty good? Yeah. I mean, yeah, I think, I think the date is a key thing.
okay.
You know what I mean? Yeah. Because then you can't really argue, well, that was done after. No, the date's right there. Photographer's signature is right there, and he dated it. So, But yeah, good question. Because, yeah, like on the spot stuff like that can be tough. Anyone else? Any questions on right of publicity? Model release forms? Thoughts, comments? Shall we move along? All right. Okay, let's talk about some sexual harassment stuff here. So quick right off the bat, your main sources of law, if you want to jot these down for future reference, are here up on your slide. Any claims that are going to be brought in court, sexual harassment claims are typically brought under these code sections. Okay, federal law and California law. Okay, so what does sexual harassment often look like? Why don't we just kind of open it up for conversation? What do you guys think? I mean, I know it's up there on the slide already, but yes.
I actually have a question that might be getting ahead.
Okay. It's sad. It's really sad and it's really frustrating. And there was a lot in there, and I want to try to unpack it. The first thing I can say right off the bat is what you cannot do is lie.
Mm-hmm.
If you're telling the truth about something that happened, you have the right to your story.
Mm-hmm.
We all have the right to tell our story, as long as it's true. If you can't lie about someone, okay, that's defamation.
Right.
Okay. Okay, let's keep this on the table right here. I want to come back to it because this is what I want. This is what I want to talk about. What can we do, right? So I definitely want to come back to this. Let's go over some basics, and then we'll circle back around because we are going to get to like what can models do, what can communities do, and all that. Okay. Here are some of the basics, right? Sexual harassment. You've got your quid pro quo. Okay, that's an offer in exchange for a sexual act. So, a photographer might say, I can get you the cover of Vogue if you perform this sexual act. Okay, quid pro quo. A threat of punishment unless the model submits to a sexual demand. So a photographer might say, or an agency or an agent might say, if you don't submit to this sexual demand, I'm going to blacklist you in the community and you'll never get a job. Okay, or we have hostile work environment. Hostile work environment is very broad, okay, super broad, and it covers a lot of different behaviors. The most important aspect to understand about hostile work environment is that any of the behaviors that are going to make up the claim of sexual harassment have to be unwanted, right? You can't be like, you know, totally having a crush on somebody and like wanting to flirt with them and flirting with them and then later saying this was hostile work environment, right? So hostile work environment, continuous unwanted sexual comments, advances, touching, groping, etc., such that the working environment itself becomes hostile, offensive, oppressive, intimidating, or abusive. This includes jokes, offers, innuendo, emails, texts, gestures, or other visual harassment, insults, or derogatory comments about a group of people, men, women, images, posters, cartoons, drawings, doodles, sketches, other synonyms for those. Excessive talking or bragging about sexual exploits. So you can see this is very broad. Hostile work environment covers a lot of ground. Yes, please.
I got a question. When they say continuous, let's say somebody sends a lady a picture that she doesn't want. Now, if he only does it once, does that not count as sexual harassment?
Unfortunately, it probably wouldn't because it's not continuous. Yeah. You know, that's not to say that the receiver of that image should not report it. Absolutely. And there should absolutely be consequences for that. But it might not rise to the level of hostile work environment.
So it'd be an HR issue.
Yeah, absolutely. Absolutely. Other questions? Yes. Yeah, I mean, there's a lot of things I could say in response to this. I mean, if I showed up to an interview and the person interviewing me was nude, not sure I'd stay for that interview. Certainly not sure I would take the job, right? I mean, hello, can we get a bigger red flag? I don't know, but that's besides the point. You knew what you were getting into is not a legal argument. I mean, unless you can argue, unless the argument is more to say, you know, that the complainant was a willing participant and was wanting these, you know, interactions to happen, and a consenting, you know, it sounds like maybe that's kind of what the argument was. But you knew what you were getting into. You know what? I need to read this case. So I don't know the facts of the case. But that sounds like a horrible situation all
I will
around.
gladly send you the case. It is very, very strange.
Yeah. Yeah. Lots of weird stuff happens out there. So we all really want, see, this is the problem with law, right? It's like there's rarely a really concrete answer for these kinds of things. And these words, you know, continuous and unwanted, are like terms of art, right? And it's like, well, what does that really mean? And well, what does reasonable really mean? And all this. So unfortunately, I just can't give you, because there isn't, well, okay, so if it's one day, it's not continuous. It has to be 2 weeks. There's just no, you know what I mean? But it also is going to depend on the actual facts of the situation, right? So, I mean, it might be an assault that occurred. And an assault is an assault, you know. That does not have to be continuous. So an assault should be reported to the police immediately. And it doesn't matter if it happens once or twice or 3 times. Once is enough. You know, if you're on a shoot for 1 day and there's someone on set who is, you know, harassing you throughout the day, I don't know. I mean, there's really
I would judge it by like proportion of time. So in that sense, even though if it's 1 day and it's continuously throughout that 1 day, I would say, you know, it does consider, you know, that is continuous under sexual harassment. because I don't think it has to be, as she was saying, like a specific number of, you know, a specific time. But if you look at the proportion of time, if it's 1 and it's continuous, then yeah, I would consider that.
So like if the job is a 1 day, a 6-hour job, let's say, okay, and there's someone who's harassing you for 5 of those hours. Is that what you're saying?
Yeah.
Look at the proportion of the job, and the harassing behavior. That could be one way. But this is a really excellent question, and worth digging into a little bit more to see how courts have interpreted continuous. Well, first of all, it's not questionable, okay? It's not questionable because you decide the scope of your consent, and that cannot be questioned. So, you know what I mean? And I'm saying this as a way to affirm your rights.
Absolutely.
You know what I mean? Not in some, I hope it didn't come out wrong.
Oh, no.
Yeah.
It's the same thing I say when I talk to girls I'm mentoring, but I also understand
Yeah.
that what you and I believe
Yeah.
as human beings
Yeah.
is different than what society says,
Yeah.
which is different than what the law says.
Yeah.
And so, helping to understand what those different nuances are, I think
Yeah.
is very important.
This is about contract drafting.
No.
This is really about contract drafting and being incredibly detailed and specific in the contract and in defining the scope of consent. And I do not advise a non-lawyer to try to do that, So that's what I can say about that. Okay, let's see. Okay, so this is not on a slide, but these are some really important things to know, okay? In terms of sexual harassment. All types and levels of employees are protected, okay? So it's not just a superior that, that can be a perpetrator, okay? So it goes both ways, it goes all around. So all types, all levels of employees are protected. This is also very important. Independent contractors are protected in California under California law, so that law up there, but not under federal law. So this is something that, your lawyer will be strategic about, in terms of bringing a claim. So there's different protections there. And state laws are more protective in terms of sexual harassment. All genders are protected. All genders are protected. Also, a genuine sexual motive on the part of the perpetrator is not required for that person's behavior to be considered sexual harassment unless it's the claim is based on quid pro quo, which is obvious, right? So does that make sense? A genuine sexual motive is not necessary. It doesn't have to be at the root. So okay. Harassing conduct outside of the work environment or outside of working hours can also be unlawful if the conduct is work related. Okay, so it doesn't just have to be at the office, or it doesn't have to just be on set or at the casting. It can be at the after party. Okay, it can be anywhere. If it's work related, then there can be a claim. Okay, an agency or management company that fails to take preventative measures with regard to sexual harassment can be liable to the victim for damages. So there must be preventative measures in place, okay, protocols and things like that. Did I hear a question coming up?
Would that also cover a nonprofit such as a guild or collective?
Absolutely, 100%, yeah. An agency or management company that is aware of sexual harassment but does nothing to stop it or aids and abets can also be liable in court to the victim for damages. Agencies and management companies are not allowed to retaliate against victims of sexual harassment for reporting or suing. Agencies and management companies are also not allowed to retaliate for testifying on behalf of someone else who is the victim of sexual harassment. Okay, I want to just make a really quick note about agencies and management companies. I said I was going to come back to that, and I haven't yet. Agencies and management companies are different, okay? Agencies are very heavily regulated. They have to be licensed. There's lots of regulations going on there. Management companies, no regulations, okay? So it's a lot more freewheeling over at the management companies, okay? So just know that. Agencies are much more heavily regulated. Okay, so this is fun. This is fun. Do we all know who this is? The name's right up there. But do we know who Karl Lagerfeld is? He is the creative director of Chanel. He has a lifetime contract with Chanel, OMG. Lifetime contract. He is quoted very recently as saying this: if you don't want your pants pulled about, don't become a model. I would like to know what you all think of that. Thoughts, comments. What do we think? Does he have a point? Does he not have a point? Is it insane? Please.
Sounds pretty bad.
Sounds pretty bad.
Yeah.
Okay, why?
Because it's kind of separating the person out of the profession and saying that, oh, this person or this profession is not under these rules, but forgetting that that is a person that is performing those duties.
And not like a rag doll.
Yeah,
Yeah,
and sexual harassment applies.
right. Absolutely. And humans have rights. Anyone else? What do we think? Please, yes.
I would imagine that's an oversimplification of everything, right? So your pants pulled about is like a colloquialism that they're using that could mean a lot of things. There's a big difference between I'm pulling a thread off of your pants versus I'm pulling your pants and looking down your pants versus pulling down your pants. There's a lot of nuances, I'd imagine, from your pants pulled about. And then also what Bertie was saying, don't become a model. We're no longer personifying the career as a model. We're just looking at it as this is a career choice. You chose to do this, so anything that goes along with it is something that you just have to accept, which goes back to properly drafting your contracts, scope of consent, and things like that. I allowed you to tailor my pants. I did not say that you could pull them off. I did not say that you could do these things. So I imagine this whole sentence was very oversimplified in his head as some kind of throwaway comment that he probably didn't think all the way through when he made it.
Definitely. And I really like the point that you made about, I'm taking it in more deeply now. I really like this point that you made about, and you picked up on that as well, about it's like, well, don't become a model. It's like, well, you become a model and suddenly you're dehumanized. Like per se, like in and of itself, the career of modeling strips you of your human rights. Which is of course absurd, but it is this implication in this comment that he made. Anyone else? So I'm going to challenge everyone to play devil's advocate, okay? Because you talked a little bit about, well, yes, you can, pull the thread, right? You can adjust my pants, but you can't pull them off. So I want to challenge the room right now to see if we can find is there any bit of like, does he have a point in any way? Well, let me jump in, and I'm so sorry to cut you off. I just want to make sure that we get everything in. And you said something that was really important that I don't want to forget. So when you said it's part of the job, right? Okay, so this is what I want to talk about. It's part of the job. So it is part of the job, everyone. To be a model, you are going to be touched and poked and prodded. It is part of the job, okay? But there are things called lines and boundaries and what's reasonable and what's not reasonable. And that's where things get really tricky. And you were talking about that before. Okay, so you can pull the thread off of my pants, but you can't pull off my pants, right? So it is part of the job when you are a model Let's say you're about to go out on the catwalk. Okay, there's a runway show, there's a fashion show going on. Things are hectic, things are crazy backstage. You've got designers, you've got directors, you've got tons of people. You've got models lined up. They're in the clothes. You've got tons of people coming by. Makeup, hair, wardrobe. Everything. People are going to be touching you. Okay, they're adjusting your clothes. They're pulling this. They're pulling that down. They're doing. And I'm sorry, but you're going to get a boob graze. It's going to happen. Okay. It might be an accident, and it probably will be an accident most of the time, but it's going to happen. So in that sense, it is part of the job, right? When you're going for a fitting, a designer is designing a piece and you are the model that the designer is fitting. They're pulling at you. They're going to look down. They need to look at seams. They need to look at this. They're going to go under the dress. They have to see the construction under there, right? So it's tough because that is part of the job. But some things go too far. And those things aren't part of the job. And those things never, never have to be accepted and dealt with. Okay? So the question is, well, where's the line, right? What's reasonable and what's not reasonable? And, everyone's going to have an opinion on that. Whose opinion is the most important? Whose feelings are the most important? Anyone? Yes, it's yours, right? You get to decide. The model gets to decide what's reasonable and what's not reasonable, and what's okay and what's not okay. And, a court might have a different opinion. The photographer might have a different opinion. The agency might have a different opinion. None of that matters. What matters is what the model is okay with. And that's the tough thing about this business is that, yeah, some of it is part of the job, so you have to ask yourself, what am I willing to accept and what am I not willing to accept? And then, legally speaking, those things need to be very clearly defined. So this comment, it's insensitive and it's poorly worded and it's not very intelligent, but you can see that there is some truth in there, right? There is some truth in there, but the question really is, what's reasonable in light of the nature of the job of modeling? And please, please do not take any of this as my condoning any kind of sexual harassment or assault or any kind of touching or groping or behavior that is not consented to. Okay, I am an absolute advocate. So, but I also advocate for having realistic expectations and having a realistic picture of what this job is and what is par for the course, what comes along with it. How can models protect themselves? Most important, if you've been assaulted, immediately go to the police, file a report. Document everything in writing, okay? If it's starting to be like, okay, something is not right here, and this is happening, just start writing it down. Dates and detailed, descriptions, okay? Tell your manager, tell your agent what's going on. Make a formal report in writing, keep a copy. If your agency has procedures in place, which they should, absolutely should, go through those procedures step by step so that they can never argue in court that you did not go through the step-by-step procedures for reporting, okay? Gotta do it. Contact a lawyer. And don't return to the environment, okay? I know, again, easier said than done. Models are ambitious, but at some point, oh God, world, please don't hate me for saying this, please. But at some point, we are responsible for ourselves, are we not? Right? So it's like, don't go back. Please don't go back. If something happens, if something weird happens, some photographer does some weird thing, and they do, just, you know what? You don't need the money that bad. You don't. And you don't need that job that bad. You don't need it. Preventative measures, okay? So some things that you can do preventatively. Oh my God, this seems like common sense, but oh my gosh, the stories are just endless, right? Going to a photographer's home studio. Just try to avoid that. Try to avoid going to shoots at photographers' homes. If you have to do it, bring a bodyguard. This is not bring another model friend, okay? This is not bring another pretty girl with you, okay, or pretty guy with you. This is bring a bodyguard, a large fellow, okay, who can protect you and who the photographer will be scared of. And this might sound crazy, but I mean, come on, right? I don't think it's crazy. Make sure that your contracts are detailed. We've said this over and over, right? Make sure your contracts are super detailed as to what you are consenting to. If you did not agree to nude shoots or shoots in your underwear or staged sexual touching, don't do it. You don't have to do it. You can walk away from the situation. Parents, I implore you, never send your child model to castings or shoots without a bodyguard. Do not do it. You would never send your child into a stranger's home, right? So just because this is a casting call does not make it any different. Parents should never send their children models to castings or shoots without bodyguards or without the parent going, right? Oh, I said this. Agencies are regulated. Management companies are not. So it's preferable to work directly with agencies, okay, instead of working with like a model management company. But again, an agency is not a substitute for having your own attorney because you and the agency have conflicting interests. Remember that. They're not your advocate. They're not your advocate. You are their bread and butter, right? So you do have conflicting interests. Changing rooms. This is often a problem, right? So like showing up, at castings, showing up at photo shoots and on jobs, and there's nowhere to change. Going to runway shows and there's nowhere to change. So ask about that. Hey, where do I change? Do I get a privacy shade? Or bring your own. Bring your own little privacy shade. You can get one. Target, Bed Bath & Beyond, whatever. Little, the things. Little shade thing. Amazon. I'm not personally endorsing any of those stores. Just saying. All right. This is really what it comes down to in the moment, right? The moment that something starts to feel uncomfortable or to seem not quite right. That moment where you're getting that little feeling inside like, oh, I don't know about this. Just trust yourself. Just stop. Just leave. Okay? You can trust yourself. That's what that little voice is there for. That little inside, okay? That's what it's there for, to inform you, to get you out of an unsafe situation. This whole idea that I've got to go to this job. I have to stay. I can't, my whole career is going to be ruined. You just have to smash that. You just have to smash that idea because it's not worth anything that might happen if you don't get out of that situation. So trust yourself. The trauma that comes from sexual assault can be lifelong. It can be lifelong. So nothing is worth that. No paycheck, no cover of Vogue, okay? And the models themselves will tell you that. Here are your resources. The Model Alliance, themodelalliance.com, founded by a former model. They've got a lot of great things going, okay, around sexual harassment and ways to report, things like that. RAIN, Rape, Abuse, and Incest National Network, RAIN.org. Read these two articles, okay? Harper's Bazaar and the Boston Globe. These two exposés are fantastic. I mean, they're deeply disturbing, but they're incredibly informative and enlightening, okay? Great resources. And then there's a documentary called Picture Me, A Model's Diary, a documentary of Sarah Ziff, who is the founder of the Model Alliance. She was a model and she filmed her early career. And so it's pretty interesting. So are there any last minute questions? Yes.
Are verbal contracts agreed to during the shoot considered legally binding?
Oral contracts are legally binding, but I do not recommend them. I do not recommend them. I do not recommend them.
If you were to write down what you're agreeing to in handwriting as opposed to type, will that still be legally binding?
Yes.
Thank you very much for watching. If you would like to see more videos by California Lawyers for the Arts, please like and subscribe to CLA's YouTube channel so we can provide full-service live streaming programs soon. Our channel will be producing videos that cover all kinds of artistic, entertainment, and intellectual property legal issues. You can also find our videos on Facebook and livestream.com.